Richard Debate. A husband told police a masked intruder had shot his wife and left him for dead. His wife's fitness tracker told a completely different story. On the morning of the 23rd of December, 2015, Connie Debate, 39, was shot dead at the family home in Ellington, Connecticut. Connie worked as a pharmaceutical sales representative, and her marriage, friends would later learn, was not what it appeared from the outside. Her husband, Richard Debate, a computer network administrator, gave officers a dramatic account. The couple had married years earlier and had 2 young sons, and to neighbors they looked like an ordinary suburban family. A tall man in camouflage, with a deep voice he compared to a movie action star, had broken in, robbed him, shot Connie in the basement, then bound him to a folding chair and stabbed him, until he fought free by burning the attacker with a blowtorch. It was a vivid story, full of specific, cinematic detail. Police arrived to find Debate tied loosely to the chair with shallow, survivable wounds, and an alarm log showing the home's panic button had been pressed using his own key fob minutes earlier. The problem was that Connie had been wearing a Fitbit. The device recorded her moving more than 1,000 feet around the house after she returned home that morning, with her movement only stopping just after 10 o'clock. That was far more than the short walk from her car to the basement, and far more importantly, it placed her alive and moving, long after the moment Debate claimed she had already been killed. The tracker, recording her ordinary movements through the house, quietly contradicted the heart of his story. It was not the only device that did. The home alarm system, the key fob records, and the family's computers all logged activity that clashed with Debate's timeline. Why would a stranger's violent break-in leave a house full of electronics, telling a story their owner could not? Investigators concluded it would not, and turned their attention to the man at the center of it. Motive was not hard to find. Debate had been having an affair with a woman who was pregnant with his child, a relationship his wife had known nothing about. He had opened a credit card without Connie's knowledge, and he moved to claim her life insurance within days of her death. Far from grieving, he had begun acting on her death almost at once. Police dogs found no scent of any intruder anywhere on the property. His own injuries were too superficial to match the desperate struggle he had described. The picture that emerged was not of a grieving victim, but of a man who had staged a crime scene around his own wife's body. Even his account of burning the intruder with a blowtorch found no support in the evidence. The case took years to reach a courtroom, delayed by the pandemic and by the death of Debate's lawyer. When it finally went to trial at a Connecticut Superior Court, jurors heard from scores of witnesses and worked through hundreds of exhibits across weeks of testimony. In 2022, a jury convicted Debate of murder, tampering with evidence, and making a false statement to police. The fitness tracker his wife had worn for exercise had become the spine of the case against him. He was sentenced to 65 years in prison with no parole. Debate appealed, attacking the reliability of the Fitbit data and accusing the prosecutor of misconduct during the trial. In 2025, the state's highest court upheld the conviction, agreeing that the prosecutor had crossed several lines, but finding the evidence against him overwhelming all the same. The court called some of the prosecutor's conduct troubling, but ruled it had not denied Debate a fair trial. Debate, who still maintains his innocence, is held in a maximum security prison in Connecticut, with a release date projected near the year 2087. Barring a successful future challenge, he will be an old man, if he is alive at all, before he is eligible to leave. The next case also turned on an object no killer would expect to betray him, though this one ended up crumpled in a bin. Jerry Westrom. For more than 2 decades, the man who killed a woman in her Minneapolis apartment was a name nobody knew. He gave himself away with a hot dog and a paper napkin. In 1993, Jean Childs, 35, was found stabbed to death in her apartment in Minneapolis after a neighbor reported water leaking from her unit. Her shower had been left running for so long, it had flooded the unit below. There were signs she had fought back hard before she died. The killing shocked the building, then slowly faded into one of the city's coldest unsolved cases. Detectives retired. The evidence sat in storage, and the woman's name slipped out of the headlines for years as the file gathered dust. What eventually broke it was a technique that did not exist when Childs died. Crime scene DNA had been carefully preserved for a quarter of a century, and working with the FBI, in 2018 investigators turned to forensic genetic genealogy, building a genetic profile and uploading it to a public ancestry database. The same family tree method that had recently cracked the notorious Golden State Killer case. A cousin match let them grow a family tree that narrowed branch by branch to one man, Jerry Westrom, a married Minnesota businessman and youth hockey father with no record of any connection to the victim at all. But a genealogy hint is not proof, and arresting a respectable family man on a family tree alone was out of the question. How do you confirm a suspect on a family tree without warning him you are coming, and without a court order he could fight? Investigators chose patience and waited for him to discard something in public they could lawfully test. They followed Westrom to his daughter's hockey game across the state line in Wisconsin and watched him eat a hot dog and toss the napkin into a bin. They collected it. The DNA on the discarded napkin matched the DNA recovered from the crime scene exactly. A bloody footprint left at the apartment, analyzed by its ridge patterns, was tied to him as well. Who was he? Westrom had lived in the Twin Cities in the early 1990s before building an ordinary suburban life. He had later brushes with the law, including a conviction for soliciting. To his neighbors, he was an unremarkable businessman and a graduate of a respected management school, which was exactly why his name had never once surfaced in 30 years of investigation. He coached, he ran a business, and he raised a family, all while the killing stayed unsolved. Arrested in early 2019, Westrom flatly denied ever having known Jean Childs, insisting the DNA had to be a mistake. His lawyers argued the original investigation had been botched and pointed at another man, an associate of the victim whose hair had been found at the scene and who had since died. It was a serious argument, but it could not explain why Westrom's own DNA was on the victim's body. Jurors were not swayed by the alternative theory. After roughly 2 hours, they convicted Westrom of first-degree murder. Because the crime had happened in 1993. He was sentenced under the rules of that era to life with a chance of parole after 30 years, meaning he could first be considered around 2052, by which point he would be an old man and his decades of quiet freedom long gone. On appeal, Minnesota's highest court affirmed the murder conviction, ruling that testing the DNA on a napkin he had thrown away in public was not a search at all under the Constitution, while setting aside a second, redundant murder count. The ruling gave legal weight to a tactic now central to cold case work, the use of so-called abandoned DNA. Held in a Minnesota prison, Westrom continues to maintain his innocence. The napkin he discarded at a hockey game had reached across nearly 3 decades to convict him, and a network true crime program later built an episode around the footprint that helped seal the case. The next case proved that even a gadget built to measure a runner's fitness can map a killer's every step. Mark Fellows. A contract killer planned his hits with cold precision, using a bicycle and encrypted phones to stay invisible. He forgot about the watch on his own wrist. Mark Fellows, a hitman from the Manchester area nicknamed the Iceman, carried out 2 killings in a long-running and bloody feud between rival Salford gangs known as the A-Team and the Anti-A-Team. In 2015, he shot dead Paul Massey, 55, a notorious local crime figure once dubbed Salford's Mr. Big, outside his home, in an attack by a gunman in military fatigues. Nearly 3 years later, he shot dead John Kinsella, 53, a Liverpool enforcer, as Kinsella walked his dogs with his pregnant partner. Fellows had used a bicycle and encrypted phones to move unseen, the kind of tradecraft that kept investigators at bay. And for a long time, the Massey case in particular went nowhere. The shooting of a man as well known as Massey outside his own home had stunned the city. Yet months passed with no charge. The break came through the second murder. As the Kinsella investigation closed in, officers from Merseyside Police, by now treating Fellows as the prime suspect, raided his home and, among his belongings, seized a Garmin running watch. A satellite navigation expert analyzed the device and found something extraordinary. About 2 months before Massey was killed, the watch had logged a 35-minute journey from Fellows' neighborhood to a field directly opposite Massey's house. The wearer had set out, traveled to that single significant location, and come straight back. The recorded pace told its own story. The wearer had cycled there at speed, slowed to a walking pace around the spot as if studying it, then traveled back the way he had come. It was a reconnaissance run, captured in detail by the very gadget meant to track his exercise. A photograph of Fellows wearing the same watch at a major city fun run, his race number pinned to his chest, placed that watch on his wrist in the very period around the killings. Could a man careful enough to use burner phones and a bike to dodge every camera really be undone by his own fitness tracker? The answer, laid out in satellite data before a jury, was yes. That single log journey, made when he believed no one was watching, tied him to the planning of a murder he had otherwise kept at a careful distance. It was the one careless act in an otherwise meticulous operation. Fellows had operated as a methodical, disciplined killer for hire, a man who moved between warring factions and left almost nothing behind for police to use. That very discipline was what made the watch's quiet betrayal so striking. The one device he treated as harmless was the one that destroyed him. At a Liverpool court in 2019, Fellows was convicted of both murders. His lookout and spotter, Stephen Boyle, was convicted of the Kinsella killing, though cleared over Massey. Fellows himself was acquitted of the attempted murder of Kinsella's partner, who had been beside him when he was shot. Fellows was given a whole life sentence, meaning he will never be released, placing him among the small group of prisoners in England held under such an order. Boyle received a life sentence with a minimum of 33 years before he can be considered for release. Behind bars, the story did not stop. Fellows was slashed and seriously injured in an attack by another inmate, needing to be airlifted to hospital in a serious condition. And in 2025, he was charged with the murder of a fellow prisoner, a case that remains before the courts and which all 3 men deny. The Iceman, undone once by a running watch, found his name back in a courtroom from inside his cell. A killer who had been so hard to catch the first time was, the second time, already exactly where the system could reach him. He had received his whole life order only a few years earlier, and now faced the prospect of a further murder trial with nothing left to lose. The next killer did not leave his evidence on a device at all. He published it and put his own name on the cover. Christian Bala. In 2000, Dariusz Janiszewski, 35, a businessman in Wrocław, Poland, disappeared without a trace, leaving behind a successful advertising business and no obvious enemies. Weeks later, his body was recovered from the Oder River, his hands bound behind his back and a rope looped around his neck, killed in a way that suggested he had still been alive when he was put into the water. Police had little to work with, no clear suspect, and within roughly half a year the investigation had stalled completely. There was no weapon, no witness, and no apparent reason anyone would want him dead. For nearly 3 years, the file sat all but closed. 3 years on, a philosophy graduate and writer named Christian Bala published a dark, violent novel titled Amok, in which the narrator binds a victim and kills him in a manner that closely matched the real, unsolved crime, including specific, intimate details of the killing that had never been released to the public or reported in the press. An anonymous tip in 2005 pointed investigators back to the book. When detectives reopened the file and compared the fiction to the facts, the overlaps were too precise to be coincidence. A character in the book even shared traits with Bala himself. Once the book had reopened the case, the circumstantial evidence built quickly around it. A single prepaid telephone card used to call the victim's office and mobile on the day he vanished had also been used to call Bala's girlfriend and his parents. The victim's mobile phone had been sold through Bala's internet auction account just days after the disappearance. A careless thread that, once pulled, unraveled fast. Taunting messages boasting of a perfect crime had been sent to police from internet cafes in Japan, South Korea, and Indonesia. The same far-flung countries Bala happened to be traveling through at the time. And there was a motive. Bala believed the victim had been involved with his estranged wife. Jealousy, prosecutors said, had driven a quiet, calculated act of revenge. Bala had suspected the affair for some time and had let that suspicion harden into something lethal. So who was Christian Bala? He had studied philosophy, run a business, and styled himself as a serious literary mind. He was intelligent, widely traveled, having spent time abroad picking up languages and odd jobs, and apparently convinced he had hidden a real murder inside the safety of fiction. Assessors who examined him described sadistic traits. He had, in effect, written out a confession and sold it in bookshops, daring anyone to notice. For 2 years, nobody had. What kind of mind buries a killing in a novel and then trusts the world not to read it carefully? It was arrogance, in the end, that put the file back on a detective's desk. The tip that named the book pointed police straight at its author. In 2007, a court convicted Bala of directing the killing and sentenced him to 25 years. The prosecution leaning not only on the novel, but on the trail of phone records, the sold mobile, and the boastful emails. An appeals court annulled that verdict and ordered a fresh trial over procedural concerns, including questions about the precise cause of death and Bala's exact role. Prosecutors pressed on regardless, confident the pattern of evidence still pointed only one way. At the retrial in 2008, he was again found guilty, and the 25-year sentence stood. The case drew international attention through a widely read magazine investigation and later inspired a feature film. Bala remained behind bars, serving that 25-year sentence after his retrial, the novelist undone by the one reader he never wanted. A detective with the case file open beside the book. His attempt to write the perfect crime had instead written his name onto a verdict. The next case left investigators with a trail of searches, a car full of weapons, and a piece of the killer himself lying at the scene. Kellen Talib Razdan. A young man walking his dog in a quiet gated neighborhood was ambushed by a former classmate. The attacker left part of his own body behind at the scene. On the 16th of August, 2021, Aris Keshishian, 20, was walking his dog near his home in a gated San Marcos neighborhood in Southern California When Kelan Talib Razdan, also 20 and a former elementary school classmate, drove to the area, ambushed him, and stabbed him to death. Razdan had come prepared, arriving by car at a spot he had no innocent reason to be. Mortally wounded, Keshishian managed to reach a neighbor and asked that his family be told he loved them. He died a short time later at a hospital, a young man killed within sight of his own home. There had been no warning, no confrontation, nothing to mark Razdan as a threat. The two had not been close in years. To Keshishian, the man waiting for him would have been little more than a face from childhood. The evidence that emerged in the hours and days afterward was as disturbing as the crime itself. Hours before the attack, Razdan had searched online for how to remove fingerprints, and in the preceding weeks, he had searched for weapons, including a sledgehammer, and, in his own words, for a city that doesn't solve murders, clicking through on the results. These were not idle searches. They tracked step by step toward what he eventually did. His car was effectively an arsenal, packed with gloves, rope, bags, a saw, a fuel can, duct tape, a box cutter, and more. It was the kit of someone who had planned for far more than a single sudden act. And in the driveway near the body, investigators found the severed tip of Razdan's own little finger, lost during the attack. It was a piece of physical evidence no staged story could ever explain away. That last detail undid him. Razdan turned up at a hospital the same day seeking treatment for hand injuries, claiming a bicycle chain had caused them. It was a thin explanation for a wound that had clearly come from something far worse. The severed fingertip recovered from the driveway matched the injury to his hand precisely. A neighbor, out walking her own dog, had seen him stabbing the defenseless victim and then calmly driving off. Her account, from someone with no stake in the case, became some of the most damaging testimony at trial. His stated motive only deepened the strangeness. He claimed someone had hacked his social media account and suspected the victim, though investigators searching his phone found no trace of any such thing. There was, by every objective measure, no reason for what he had done. Who was he? Razdan had a traumatic early childhood before being adopted at a young age into a San Diego County family. A defense evaluation later raised the possibility of a serious mental health diagnosis, though it was not argued at his trial, where he instead claimed self-defense and harassment. The jury heard a very different version of events, one built on his searches, his weapons, and the calm with which he left. The disinterested eyewitness, the searches, the weapons, and the piece of his own hand left at the scene all pointed the other way. Together, they formed one of the most self-incriminating trails imaginable, much of it created by Razdan himself in the hours before he killed. A California jury rejected his account and, after about 2 hours, convicted Razdan of first-degree murder. He was sentenced to 26 years to life. His appeals are now exhausted. A state appeals court affirmed the conviction in 2025, rejecting every challenge, including his objection to the internet search evidence the jury had been shown. And the state's Supreme Court declined to take the case any further, exhausting his direct path of appeal. A wrongful death lawsuit brought by the victim's family, which also names Razdan's adoptive parents, is still working its way through the courts. For the family, the criminal verdict closed one chapter, while the civil case kept another open. If you have made it this far and you are enjoying these cases, take a moment to subscribe, because the stories only get stranger from here. The next case featured a killer who did not just leave evidence behind, but posed with it and put it online. Amanda Taylor. Most killers try to hide what they have done. Amanda Taylor posed for a photograph with a murder weapon and put it online. On the 4th of April, 2015, Amanda Taylor, 24, killed her former father-in-law, Charles Taylor, 59, at his home in the Alette-Ironto area of rural Montgomery County, Virginia. She had gone there with an accomplice, Sean Ball, 34, on the pretext of asking for money for the Easter weekend. The pair arriving armed with a knife bought from a military supply store and a crowbar. It was not a robbery gone wrong, but a visit with a settled purpose. Once inside, Amanda stabbed Charles to death in a sustained and frenzied attack. Afterward, the two fled south, driving through Tennessee toward North Carolina as police began to piece together what had happened. Rather than lie low, Amanda turned to her phone. The motive lay in a death the year before. Amanda blamed Charles for the downfall of her estranged husband, Rex, who was Charles's son and who had taken his own life after struggling with addiction. She held the older man responsible for that addiction and for Rex's death. And she carried the grievance to his door along with a weapon. In her mind, the killing was an act of revenge on behalf of the man she had lost. She had nursed that anger for months before acting on it. What set the case apart was that Amanda documented it herself. She posed holding the bloodied knife near Charles's body, and the image was put online, reportedly to a website devoted to killers. On her social media accounts, she wrote in effect that she had proudly done it for Rex, naming the husband whose death she was avenging. In recorded interviews, she compared the killing to her first ride on a roller coaster, saying she had felt excited, calling it a personal kill, and admitting she had wanted to watch him die. In one interview with a local television journalist, later played to the jury, she spoke about the death with chilling detachment. Throughout, there was a striking absence of remorse. How often does a murder case arrive with the killer's own confession already published for anyone to find? Amanda was arrested on the Blue Ridge Parkway in North Carolina, with her own words and images already in the open. There was little mystery left about who had done it or why, and the investigation moved quickly toward trial. The hunt for the pair had stretched across state lines before they were stopped. The recordings of her interviews, in which she spoke about the killing with something close to satisfaction, would prove just as powerful in court as the photograph itself. Jurors heard her describe the act in her own voice, unprompted and unrepentant. At trial in November 2015, her defense rested without calling a single witness. The jury deliberated for under half an hour before convicting her of first-degree murder and recommending a life term. Few cases gave a jury so little to weigh. The judge later called Amanda evil personified and pointed to her near-total lack of regret for what she had done. He upheld the life sentence the jury had recommended. Who was she? Amanda was a young mother whose life had come apart around her husband's addiction and death. She had known Charles for years through her marriage to his son. But the grief she described had curdled into something colder, a desire not only to punish, but to perform, to be seen doing it. Even after her conviction, she did not soften. In a later interview, she said plainly that she had absolutely no remorse, words that matched everything the case had already shown. Amanda Taylor was sentenced to life in prison, a term later upheld on appeal. She is held at a women's correctional center in Virginia, where she has continued to speak about the crime without apology. Sean Ball pleaded guilty to second-degree murder and received a sentence of decades, with release projected far into the future. The woman who had turned a killing into a photo opportunity would spend her life paying for the image she could not resist posting. What she had meant as a trophy became the centerpiece of the case against her. The next case also turned on a recording, though this one was made not by the killer, but by one of his victims. Alex Murdaugh. a prominent lawyer built his alibi on being far away when his wife and son were killed. His murdered son's phone placed him at the scene minutes before they died. On the night of the 7th of June, 2021, Maggie Murdaugh, 52, and her son Paul, 22, were shot dead near the dog kennels at the family's sprawling estate in Colleton County, South Carolina. The killings stunned a county where the Murdaugh name was almost synonymous with the law. Paul was killed with a shotgun and Maggie with a rifle, and neither weapon was ever recovered. It was a calculated, close-range double killing on the family's own land. Alex Murdaugh, a personal injury lawyer from a South Carolina legal dynasty whose members had served as the region's chief prosecutor across 3 generations, told police he had been visiting his ailing mother and had discovered the bodies when he returned home at around 10 o'clock. He played the role of a grieving husband and father even as suspicion gathered around him. The story did not hold. Minutes before the killings, Paul had recorded a short video at the kennels on his phone. In the background of that video, investigators could hear Alex Murdaugh's voice, placing him at the scene at the very time he insisted he had been elsewhere. The recording shattered his alibi. Confronted on the witness stand, Murdaugh admitted he had lied about being at the kennels that evening, blaming paranoia brought on by an opioid addiction. It was a stunning reversal, the defendant conceding under oath that the story he had told from the start was false. Jurors would later say the kennel video was the moment that sealed the case against him. A few seconds of audio had done what nothing else in the trial could. Why would a man kill his own family? Prosecutors argued that Murdaugh had done it to buy himself sympathy and time, because his life was collapsing. For years, he had been stealing on a vast scale from his law firm, his clients, and others, sums running to millions of dollars, including a settlement of several $1 million owed to the family of his late housekeeper, which he had funneled into a sham account he controlled. Exposure was closing in, and the murders, the state argued, were a desperate act of distraction to reset the clock on everything bearing down on him. By killing his family, prosecutors said, he had hoped to turn himself from suspect into victim. After a trial lasting around 6 weeks, in March 2023, a jury convicted Murdaugh of 2 counts of murder, and he was given 2 consecutive life sentences. The jury reached its decision in only about 3 hours. Separately, he pleaded guilty to dozens of financial crimes, drawing a 40-year federal sentence with millions in restitution, along with a long state sentence on top of it. The federal judge ordered him to repay more than $8 million, and a separate state court handed him a further 27-year term for stealing from clients and his own firm. For a time, by any normal measure, the case looked closed. Then it turned again. In May 2026, South Carolina's Supreme Court unanimously overturned Murdaugh's murder convictions and ordered a new trial, finding that the local clerk of court had improperly influenced the jury, in the court's words, placing her fingers on the scales of justice. The clerk, named in the appeal, had written a book about the trial and was found to have spoken improperly to jurors. She later pleaded guilty to misconduct and obstruction and received probation. The state attorney general announced he would aggressively seek to retry Murdaugh for the murders, hoping to bring the case back to court before the end of the year. Crucially, none of this set Murdaugh free. He remained in prison the entire time, serving the lengthy state and federal sentences for his financial crimes while awaiting a possible second murder trial. Who was he in the end? A man whose name had once carried enormous weight in his corner of South Carolina, brought down in part by the final recording his own son ever made. Whatever a new jury eventually decides, the financial sentences ensure he will not walk free for decades. The next case saw a husband betrayed by the fitness app, counting the steps on his own phone. Mitesh Patel. A pharmacist called police to report that an intruder had attacked his wife. The fitness app on his own phone had been recording him stage the scene. On the evening of the 14th of May, 2018, Mitesh Patel, 37, strangled his wife, Jessica Patel, 34, at their home in Linthorpe, Middlesbrough, in the north of England. He then ransacked the house, bound her wrists and ankles with tape, and called the emergency services claiming an intruder had broken in and attacked her. He disordered the rooms and scattered belongings to suggest a search for valuables. To the first responders, it was meant to look like a burglary that had turned deadly. Patel even feigned distress as help arrived, a performance that began the moment he dialed for help. The staged scene did not survive the evidence held on his own devices. The health app on Patel's iPhone had quietly logged his movements, counting his steps as he hurried up and down the stairs, arranging the scene around his wife's body. His home security cameras, installed by Patel himself, captured still more. And his internet history was damning. He had searched online for how to kill his wife and had looked at material on methods of killing. He had typed his intention into a search box in plain words, then watched videos on how to carry it out. The devices inside his own home laid out the truth while he gave police a story. Step counts, timestamps, and camera footage formed a record he could not talk his way around. Could a man methodical enough to fake a break-in really forget that the phone in his pocket was keeping count? He had thought of the ransacked rooms and the cut tape, but not of the quiet sensor logging his every step. The motive lay in a life Jessica knew nothing about. Patel used a dating app almost every day under an assumed name, had a string of encounters with men, and was in love with a doctor living in Sydney. He and Jessica, married for nearly a decade, had been trying to start a family and had pursued fertility treatment together. They had stored embryos through that treatment, which, the court heard, Patel intended to use to build a family of his own abroad. Prosecutors said Patel planned to collect a life insurance payout of around £2 million, emigrate, and begin a new life with his lover. Everything he wanted lay on the far side of his wife's death. Jessica, in his plan, was the obstacle that had to be removed. She had no idea, those who knew her said, that her husband saw her that way. At Teesside Crown Court, after a trial lasting roughly 2 weeks, a jury convicted Patel of murder in December 2018. The evidence drawn from his own devices, alongside the unmasking of his double life, left little room for the burglary story he had told. By the end, the intruder he described existed only in his account. He was sentenced to life in prison with a minimum of 30 years. The judge telling him he had shown no remorse, and that any pity he felt was reserved for himself. It was one of the longest minimum terms handed down in the region for such a case, reflecting how coldly the killing had been planned. A later official review concluded that Patel had subjected Jessica to years of controlling and coercive behavior, and it discussed the killing in the language of a so-called honor killing. Jessica, it found, had endured far more behind closed doors than anyone outside the marriage had known. He will not be eligible to be considered for release until around 2048. By then, the second life he had killed for will be long out of reach. Behind the respectable pharmacist, the case revealed a man leading a double life who had decided his wife was something to be cleared out of his way. He had run a pharmacy with Jessica at his side while planning the life he meant to lead without her. The final case turned on a search history that laid bare a killing planned in cold, deliberate detail. Saini Marong. A killing was made to look like a sudden, senseless attack. The killer's own search history showed it had been planned in deliberate detail. On the 14th of May, 2016, Sini Morong picked up Renee Duckmanton, a young Christchurch woman, strangled her, and set her body alight, leaving her on a rural road outside the city. Her badly burnt remains were found there days later. She had been picked up from the part of the city where she worked, then driven out to a quiet stretch of road to die. Morong, a butcher who was already subject to a deportation order in New Zealand, was arrested about 10 days after the killing, and what investigators found on his devices would define the case. He had come to the country from the Gambia and was facing removal even before the murder. What turned a brutal killing into a clear case of premeditated murder was Morong's internet activity. Without it, a defense of sudden deranged violence might have found more room to breathe. In the period beforehand, he had made a series of disturbing searches about finding a victim and avoiding being caught. They pointed to planning rather than impulse, a man researching how to carry out and escape such a crime before he ever acted on it. Each search was a step taken in advance, a decision made long before the night itself. He admitted strangling Duckmanton and setting her alight, but argued it was not murder, claiming he had been mentally disconnected from reality at the time, even offering a bizarre physical explanation for it. His claim that an illness had clouded his mind and cut him off from reality was as strange as it was convenient. He reportedly described the killing to prison staff as being like hunting in the wild. It was a remark that captured the coldness running through the whole case. Mental health experts who examined Morong rejected his account. A psychiatrist and a psychologist both concluded that he did not meet the legal test for insanity and that he had known exactly what he was doing. There was, in their assessment, no mental illness capable of excusing what he had planned and carried out. His searches, carried out coldly in the days before the crime, made the claim of a sudden breakdown impossible to sustain. A breakdown does not announce itself in a search bar days ahead of time. How could a man who had researched his crime in advance claim he had not understood what he was doing as he did it? Duckmanton was a vulnerable young woman. She had a disability that affected one side of her body and was small in stature, and Morong had singled her out deliberately, knowing she would be easier to overpower. She was, by every account, someone who should have been able to expect protection rather than predation. That vulnerability, together with the planning behind the crime and its particular callousness, would weigh heavily when the time came to sentence him. The contrast between her and the calculating man who killed her ran through the whole case. On one side, a defenseless young woman. On the other, a man who had rehearsed her death online. After a 2-week high court trial in Christchurch in 2018, Morong was found guilty of murder. The jury did not accept that he had been anything other than fully aware of his actions. He was sentenced to life in prison with a minimum of 18 years before he could be considered for parole, a year above the standard minimum, set higher because of 3 aggravating factors: the calculated planning, the particular callousness of the killing, and the vulnerability of his victim. Judges rarely move above the baseline lightly. Here, the facts left them little choice. Morong challenged the sentence, but the Court of Appeal upheld the 18-year minimum, and the Supreme Court dismissed his final appeal, finding no miscarriage of justice in his conviction or his sentence. Duckmanton's mother said she hoped he would never know freedom again. For her family, the verdict and the long minimum term offered a measure of justice, though no relief from the loss. Morong remains behind bars in New Zealand, serving his life sentence. The searches he made before the killing standing as lasting proof that what he had tried to pass off as madness had in fact been a plan. This was all from our side today. Thanks for watching. Click here to check out another video.